sticks by her animals.
The pit bull was the precipitating factor.
According to her.
No, according to me.
I'm sorry, can I interrupt?
No, you can't.
This is Judge Judy. Estela Hernandez is suing her former neighbor, Myra Solis, for vet bills and punitive damages after Myra's dogs attacked her pony.
Judge, this is case number 11 on the calendar in the matter of Hernandez versus Solis. Parties have been sworn in. Siéntese, por favor.
Thank you. Ms. Hernandez, you have a horse, and you and the defendant are neighbors.
Yes.
Is that correct?
Yes.
It is your claim that some time ago, it was actually back in December of 2018, for the second time, dogs that belonged to the defendant injured your horse.
Yes. The first injury was in October, actually, of 2018.
And when that injury happened, according to you, the horse's legs were bitten.
Yes, we have one horse.
Is that right?
Yes.
We're not involved with that instance in this court case. What you're really talking about is the incident that happened in December. But I want to know whether or not you, as a neighbor, knew what the defendant's dogs looked like.
I didn't know.
You did not?
No.
So these were not dogs
That my husband saw
No.
and my neighbor saw, yes.
Well, I don't know about your neighbor, but your husband is there.
Yes.
So now I'm going to ask your husband. His last name is?
Hernandez.
Mr. Hernandez, would you step up, please? Mr. Hernandez, can you tell me what you observed in December of 2018?
I heard some noise 4 o'clock in the morning. When I go outside, I see my pony in the driveway, and I see my pony bleeding a lot. And I go to check, and I see like 40 feet in the front, the same dogs, the pit bull and German Shepherd, waiting for him.
I'm sorry, can I interrupt?
No,
Your Honor,
you can't.
the
When I come
statement-
to you, listen to me. When I come to you and ask you a question, you can answer me. Do you understand?
Yes, Your Honor, but in his
Good,
statement, he's
perfect.
claiming a husky.
No, he didn't say a husky.
He said a
I
hus-
want you to just pay careful attention to me.
Yes, Your Honor.
When I come to you, you can talk.
Okay, Your Honor.
Right now, I'm not addressing you. Do you understand that?
I understand.
Now, you saw a pit bull and a German Shepherd.
Yes,
Had you ever seen these dogs before?
like 15, 16 is the first attack to my pony.
After the October incident, when your pony was hurt, did you speak to the defendant?
Your Honor.
Next day.
speak to her?
Next day.
The next day, you spoke to Miss Solis,
No.
or your wife did the next day. Who? What part of don't speak don't you understand?
Sorry, Your Honor.
Who spoke to Miss Solis, you or your wife, the next day? Back in October.
My friend called me. The dogs go to your property again. When I go outside, I see the dogs for first time.
Was that a pit bull and a German Shepherd?
Yeah,
Those were the two dogs. That was back in October.
yeah, and October 15. And I
Okay.
see it October 16 is the first time when I see it in my property.
Okay.
When
What kind of dogs did you see?
pit bull, like gray, and a German Shepherd.
Okay. And are those the same two dogs that you saw in December
Yeah,
after your horse was again injured?
Yeah, the same dogs.
And your pony was both times, both in October and December, on your property?
Yes, inside my property.
Okay. Sit down, Mr. Hernandez. Thank you very much. Ms. Hernandez, how long has the...
Oh, I don't know her, but we moved into this property July of 2013.
And how long has the pony been with you?
We bought her, I believe, that end of that same year. So could be like November, December.
2013.
2013, yes. Because this
2013.
horse was bought for my daughter. So that's when she was born.
Up until the October incident, have you had any trouble with any other animals and your pony?
No.
There have been no other incidents. Okay.
No.
Now look at me. Now I'm going to talk to you. Do you understand, Miss Solis?
Yes, Your Honor.
Okay. Do you live in a house?
Yes.
Who do you live in the house with?
I live with my mom, my dad, my son, my daughter, and my little sister.
And how long have your mom and dad lived in that house?
Since 2010.
When did you move in with them?
So basically, we moved in. I mean, I've been with them. I just recently separated from them this year.
So you've lived with them?
Yes.
And when did you get the German Shepherd?
We got the German Shepherd when my little sister was about...
Jade, look at me. Look at me.
I'm looking.
Very good. Just look at me.
Okay, I'm looking.
In what year did you get the German Shepherd? Look at me.
Sorry, I'm trying to think. I was about 8 years old. I'm 24 now.
What year did you get the Pit Bull?
We recently, months when the incidents happened. So August.
Okay, so you got the Pit Bull.
August 2018.
In 2018.
Yes.
So the Pit Bull was the precipitating factor.
Yes. Correct, according to her. Pit Bull was kind, Pit Bull was loving.
No. According to me.
According to you,
me.
Your Honor?
According to me. Well, ordinarily I wouldn't let you, but I'm trying to educate you.
Educate
I'm
me
trying to educate
on
you.
a pit bull?
Yes, I'm trying to educate you, so I want you to be quiet.
Okay, Your Honor.
If you want to be educated, then you'll be quiet. The reason I'm saying the Pit Bull was the target date because the plaintiffs have lived in their home since 2013. Mm-hmm. You have lived in your home with your family since 2010. Mm-hmm. They have had no problem with anything attacking their pony 2013, 14, 15, 16, and 17 until well into 2018. You had your German Shepherd since, according to you, you were 8 years old.
Yes.
Do you understand so far? Do you understand where I'm teaching you logic?
Yes.
In 30 seconds, I'm teaching you a 6-month course in logic.
Okay, Your Honor.
The only time that they had trouble with their pony being injured, property, and once in December, in an incident involving a pit bull, which is when you got your pit bull in 2018. Nothing happened with your German Shepherd in 2013, 14, 15, 16, 17, or 18. The only date consistent with this injury is with the pit bull in 2018. Did I just teach you logic?
Yes, Your Honor.
All right. Can I see the vet bill, please?
I also have a report from the vet. She wrote out a statement.
I'd like to see it.
Okay.
We both put it
I would like to see it. Just a second. Who wrote this?
This is
Yes.
Dr. Sally. This is the doctor that actually came out and did the surgery.
Okay, got it. Okay.
So I'd like to add, Your Honor, that she actually treated the horse, but at the time that she was treating the horse, we also showed her what other injuries the dog had had that consist with an attack, and she agreed, and that's why she wrote out the statement.
No. God. Would you show me the bills from the vet?
So, I believe this is the first one. Let me know when I can go ahead and put the second one.
Yes, and show me the second one, please.
Second one.
See the
Got it.
second vet bill?
Can I go ahead and finish
Yes.
putting these up, Your Honor? There's more than
Yeah, it doesn't make any. I just want to see proof of
Okay.
that the horse was taken to the vet. Now, after the October incident, did you speak to Miss Solis?
After the October incident, I sent her a text message letting her know that if we can have a discussion regarding these vet bills, and I never got an answer from her.
Okay. Do your
Can I
parents
interrupt?
own or lease the house? Do your parents own or lease the house?
Lease.
Do they have insurance on the leased house?
Yes,
Do they have homeowners insurance?
they do. They have homeowners insurance.
Did they notify the homeowners insurance that you had had a pit bull in your house?
We actually were just fostering, and my parents, they have nothing to do with that. We were fostering the
What do you
pit
mean they have
bull.
nothing to do with that?
We were fostering the pit bull. We were just doing our research as to what we needed to be able to, go ahead and keep our pit bull here at the house. We didn't even get a chance to do anything of that. We had no chance.
Judge Judy continues in a moment.
So what did you do with the pit bull?
I had to give her up.
You didn't give her up in October or November
They
or
came
December.
Your Honor, I was informed by Animal Control.
Listen to me. I'm not speaking to you.
And later today,
From her as a deposit. Did you rent the studio?
Not to her.
Have you rented the studio?
It is rented right now.
Let's not play with me.
Estela Hernandez says dogs owned by her former neighbor, Myra Solis, attacked and injured her pony.
Okay. Can you tell me why you never responded to the plaintiff's initial text in October?
I did respond, and we did speak on the phone, we had a conversation on the phone, and I said, hey, you know what? They had mentioned a video of evidence that my 2 dogs were attacking her pony. Even the animal control, they said that they had a video, and I said, please go ahead and show me the video. I would love to see the video. And, you know, I would have went ahead, if I saw that those were my dogs, I would have had no problem paying her the original $270 that she said that I owed. But they never showed me the video. They failed to show me the video. And so then I said, okay, well then.
She wanted me to wait,
so
Your
what
Honor.
did you do with, so what did you do with the pit bull?
I had to give her away.
After October?
I had to give her away. I had to give her up. They were asking me.
Just a sec. On what date? You didn't give her up in October or November or December.
Your Honor, I
Listen to me. I'm not speaking to you.
Okay.
You didn't get rid of the pit bull
I did, Your
in
Honor.
October, November. On what date? Can you prove to me that you got rid of the pit bull?
They came. They gave us a warning, the first attack in August.
What date?
Your Honor, I have to look
What
that
date?
up. I am not sure.
Just tell me what date they came and took the pit bull.
It was after the second incident, after December, so it was not in December.
Okay, very good. Judgment for the plaintiff in the amount of $3,000. You want to keep a dangerous dog? That's your problem.
Your Honor,
Because
this pony's going to need treatment. It's going to need therapy.
We're finished. We're done. Thank you very much.
Thank you.
We're done.
This case is concluded. Parties are excused.
She gets to go and go look at their pony in their backyard, but I lost 2 dogs.
I think it was fair. I think if you're going to be a pet owner, you should be a responsible pet owner.
It's a traumatic event.
Just tragedy all the way around.
All parties in the matter of LaBraine Jackson versus Oswald. Approach the podium, please.
Brenda LaBraine Jackson is suing her former landlord-to-be, Jerome Oswald, for the return of a deposit on an apartment she never moved into.
Miss LaBraine Jackson, you want your deposit back on an apartment that you rented from the defendant.
Yes.
It is your claim that the apartment wasn't ready in time. Prior to March of this year, where were you living?
I was living with my parents.
And you had been living at home with your parents for a long time.
Yes. Maybe
So
5
this
years.
was a move-out experience because you were working in January for whom?
In January, I was working at a medical spa, and I work at Burke Williams. I'm a massage therapist.
So you had 2 jobs.
Yes.
And you had those 2 jobs when you first saw the apartment in March.
Absolutely. Yes. I
Correct?
did. Yes. Correct.
And at that time, you gave the defendant $1,450 to hold the apartment for you.
Yes.
So he stopped showing it to anyone else.
Yes. Correct.
In March, both of those jobs went away because of COVID. Is that correct?
Yes. Correct.
So by the time you were supposed to move in April, you had no source of income.
Absolutely right.
Okay. So let's not blame the defendant for why you changed your mind about moving into the apartment. You changed your mind about moving into the apartment because you couldn't pay rent, because you weren't working because of the pandemic.
Yes.
Judge Judy continues in a moment.
You had a contract with him. Just because you didn't have a written contract doesn't mean you didn't have a contract. He offered his apartment. Of that, he took it off the market. That, madam, is a contract.
Real cases, real people. Judge Judy. Brenda LaBraine Jackson says Jerome Oswald won't return a deposit for an apartment she never moved into. Jerome is countersuing for the cost of the renovations she requested.
Now, I'd like you to tell me about what the apartment looked like when you first saw it in March.
When I first saw the apartment in March, the apartment was not move-in ready.
What was wrong with it?
There was no cooktop. There was no shower. The shower, he had just started to fix it and actually build a shower. There
You
was
mean redo the shower?
Yeah, yeah.
How large an apartment was it?
It's a studio back house.
Is it a one-bedroom or studio?
Yeah, studio.
Had you rented this studio before, sir?
Yes, ma'am.
And you asked the defendant to make certain changes as long as he was doing renovations in the apartment. What changes did you want?
He had a TV in his studio back house, and my son and I, we really don't watch TV, and we didn't want to be held accountable for anything that could have, may have happened with the TV. So I kind of asked him to just remove it just so that we could.
You asked him to build any additional closet space or anything else?
No, I did not.
Nothing else? Just remove the TV.
Yes.
What else did the plaintiff, according to you, ask you to do in the
She asked me to
apartment?
remove all the upper cabinets in the kitchenette and also remove the TV, which was actually mounted to the wall. So, you know, I had to repair the walls.
Okay.
And also install a medicine cabinet in the bathroom and install a organizer in the closet.
Okay. Any of that sound familiar?
Most of it does. The only thing that's not true is the fact that I was the one that provided the closet organizer, and I told him that I wouldn't mind installing it if it was okay with him, you know, to be able to do that in his unit.
So this is the problem that you have. The problem that you have is that you decided not to move into this studio with your son because you lost your job.
Yes.
That was the reason.
Absolutely.
And that's not Mr. Oswald's problem. You know, it's unfortunate, but if he was holding that apartment for you, that was your arrangement.
Yes.
He stopped showing the apartment so that because you were going to be the tenant. So you don't get your deposit back if you decided not to move in because you lost your job. I feel terrible that with your son, but you gave him the $1,450 to hold the apartment so that he would take it off the market and not show it to anyone else.
I agree with that, Your Honor.
That's the reason.
The
reason.
The only thing with that, though, is he never gave me possession of the place. I never received keys for the place.
You don't have to receive keys for the place, madam. The reason that you decided not to move into the apartment is because you lost your job, period.
Judge Judy continues in a moment. Closed captioning sponsored by... Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
Mr. Oswald,
Yes.
let's be serious about this. Money owed for special renovations, $1,500. You got $1,450 from her as a deposit. Did you rent the studio?
Not to her.
Have you rented the studio?
It is rented right now.
Let's not play with me.
Pardon
It's
me?
rented. And when did you rent it?
The beginning of July.
Good. So you were out a few months, but there's a pandemic in this
Yep,
world,
exactly.
and everything is sort of upside down. So you were without rent for a little bit, and you're back home with your parents. Is that right?
I actually moved to Louisiana
Why?
because it's more economically viable for me at the moment.
You mean cheaper than
It is.
Did you move in with somebody
No.
in Louisiana?
No, it's just me and my son.
And your parents live where? In California?
Yes, they live in California.
Listen, I don't have time to go into that decision-making process of yours. I assume you're not living for free in Louisiana.
I have relatives in Louisiana as well.
Are you living with relatives in Louisiana?
At the moment, I am, but I do have an apartment that I'm going to be renting in
Great.
September.
Okay. Both the claim and the counterclaim are dismissed. Thank you very much. We're finished here.
I do want to say, though, he never signed the contract. Does that not matter?
We're done. No, you had, just so that I answer you, and I don't have to answer you, you had a contract with him. Just because you didn't have a written contract doesn't mean you didn't have a contract. There was an offer, an acceptance, and consideration. He offered his apartment. You accepted his apartment. You gave him $1,450 to hold that apartment. In consideration of that, he took it off the market. That, madam, is a contract.
But
I've just given you contracts.
though?
101 in law school. We're finished. Goodbye.
This case is concluded. Parties are excused.
Judge Judy continues in a moment. And on the next Judge Judy.
How were you contributing to the household?
Mostly I cleaned.
Other than being tidy, he paid with his mother.
Judge Judy.
I'm pleased to hear that I don't have to give a deposit back.
I think that it was fair.
She wasn't willing to work at all with me.
I thought there were certain things, certain laws in place, contracts and stuff like that.
Probably be a little tougher, I guess.
No more money up front.
An entrepreneur cashes out her company.
You sold that business to the defendants.
Correct.
For how much?
$800,000.
But
There are 3 things that they have signed off on that I have problems with.
did she mess
You went to mediation. You hired an attorney.
with their success?
What proof do you have that she libeled, slandered you, and caused you to lose business?
This is Judge Judy. Janie Furling is suing Russell and Juliet Slaybaugh for legal fees resulting from the sale of her business.
Judge, this is case number 21 on the calendar, the matter of Furling versus Slayball. Parties have been sworn in, Your Honor. You may be seated.
Ms. Furling, you had a T-shirt screening business?
Yes, silk screen printing.
And in 2017, according to your complaint, you much?
$800,000.
And were you paid in 2017 the majority of the $800,000?
Yes, I was.
How much were you paid?
$720,000.
And when were you supposed to receive the other 80?
It was a 5-year note, and they had the first 2 years deferred with interest only, and payments were supposed to begin February 1st, 2019.
According to your complaint, for whatever reason, the defendants were in default of that $80,000, or part of it. And your contract with them provides that if you have to use any legal means in order to enforce that $80,000, that you would be entitled to legal fees. You acknowledge, Mr. and Mrs. Sayborg, that that's what the contract says.
Yes.
Mm-hmm. Your complaint is that you agreed to go to mediation. You went to mediation, you hired an attorney, you paid for the mediation, which was unsuccessful, at least in part because Mrs. Slaybog didn't show up.
That's correct.
So my first question, just a second. So my first question to you is, what was the date of the mediation?
January 8th.
Of what year?
2019.
Oh, 2020.
I'm sorry, 2020. I'm sorry, 2020.
On the contract for the sale of the business?
Yes.
Do you have a document that shows me that you had given your husband your power of attorney on that date to mediate?
No. I don't have a document, no.
Were you hospitalized?
No, I had the flu, though. I was sick.
Do you have medical note to show me that you were sick?
No.
Then you have to pay her legal fees.
Ma'am,
then you have to pay her legal fees.
I am an officer of the corporation as well.
Is.
So we were essentially negotiating for the corporation.
No, you were both supposed to be there. Your wife said she had the flu. Did the matter go to mediation? Did you each testify?
We both, we went, both parties went to mediation, Your Honor,
No.
yes.
I did not testify.
Well, not all the parties went to mediation. Your wife didn't go, and she was a signatory to the contract.
That's true.
She was a signatory to the contract.
But the corporation essentially was the entity.
Well, you say the corporation went. Who signed the contract?
Both she
both
and I
did.
as officers of the corporation.
Just a second. Hold on. No, this purchase and sale agreement was between the two of you, Russell and Juliet Slaybaugh, or a corporation to be created but had not been created, so you and your wife.
No, ma'am.
I don't see anybody signing it.
That was signed in December. I think in December of 2019, the corporation was
2016.
16, sorry, yeah.
In December 28th, 2016.
Right, the corporation was formed December 20th of 2019, and all of the escrow, 2016. Mm-hmm. And all of the documents, all the escrow, everything is done in the corporate name thereafter.
I don't care. What I have are the documents that indicate that you and your wife both signed the purchase-sale agreement. That's what I have.
Well, right,
That's all that I have.
Ma'am, I think that purchase
That's all that I have.
I think that purchase and sale agreement specifies that a note would be created. The note was ultimately created during the escrow process. And then there's terms within the note that specify kind of the way things went. So there was an offset provision in the note.
Would you tell me why your wife didn't show up to the mediation?
Because she didn't want to get everybody sick. I mean, she wasn't feeling well. She didn't want to get everybody sick. I mean, I guess, especially these days, we should appreciate that.
Did you call the plaintiff or the mediator that morning and say, my wife is sick, we have to postpone this mediation? Just answer my question. Did you call? And don't you think that that's a little outrageous?
No, ma'am. In fact,
don't you think that that's a little outrageous?
I think actually I'd like to take a look at the mediation. I believe the mediation was called out in the corporate name, so there was a corporate representative.
Why don't you pay attention to my question? Mm-hmm. My question was, if your wife wasn't feeling well, civilized people put in a call to the mediator who was being paid and to opposing counsel or their opposition and say, My wife, who may or not be there as a witness, is not feeling well today. We're going to have to postpone.
We may have. We may have mentioned to the mediator. We saw it as a corporate matter, and we had officers of the corporation.
Okay. Now, do you have a separate matter pending for any of the balance of this $80,000?
I don't have any matter pending.
Do you?
No. A separate matter? Well, there are three things that they have signed off on that I have problems with, and before I can take them to court and actually sue them on these things, I had to agree to mediation. And so that's why we went to mediation first.
That's not true.
Just a second. So what you are telling me is that you do intend to sue them for whatever balance there is of that $80,000.
There is the possibility.
Is that what you're telling me?
Yes, there is the possibility of that. I'm not sure that I would get any money if I did take them to court. I've been advised how much it would cost me to take them and the chances of collecting. I have a statute of limitations that I've been advised on, and so I still have
Ms.
time.
Furling, you have to understand that I am not entertaining your case unless I have a clear, unequivocal statement that you do not intend to pursue the balance of the purchase price, because in that proceeding, you will be entitled to counsel fees. So I need a clear, unequivocal statement that they are going to rely on, that you have no intention and you will not be filing a lawsuit against them.
At this time.
And it will be binding.
At this time, I do not have any plans.
Not at this time. Sorry. Doesn't work for me.
Right.
You have to say clearly, unequivocally, that you will not file a lawsuit for the balance of the purchase price, because in that lawsuit, pursuant to your contract, you would be able to seek counsel fees. I am not going to entertain your case unless you don't say to me at this time. You have to say to me, I will not file a lawsuit against the defendants for any part of the purchase price. This, including counsel fees. Do you understand?
I do understand, but may I back up a little bit?
Okay,
This is not the first time that I have sought legal fees. We had a first set of lawyers when they first defaulted on the loan, and I had to hire a lawyer, and we did a lot of back and forth, and it came to a certain amount, and they paid for it. I'm entitled to be reimbursed for enforcement and collection.
Very good. I have to tell you, I'm not repeating myself again.
Well, I guess I will say so.
I'm not repeating myself.
Yes, I will not pursue it. I will not pursue the $80,000 that they owe me on the non-negotiable note in the future. And I would like legal fees to reimburse me.
Counsel fees.
I'm sorry?
Then you're entitled to counsel fees. What were your counsel fees for the mediation?
It came to, I have it written down, it was $4,000.
No,
You want me to get the exact agreement?
Yes, I want you to give me the exact. You're entitled to counsel fees.
Yes, I have it right here.
For the mediation.
I spent $2,500 for the lawyer.
I'd like to see proof of that, please.
There's the first check, which was $500. Would you like me to put in the second one?
Yes.
That's the second one for $2,000.
Okay, good. Next.
And then ADR services came to $23.75.
That was for the mediation service?
That was for the mediation service. And here's the proof of payment was done on my credit card.
That comes to $48.75.
Yes.
Yeah, that's your judgment. Now, you have a counterclaim. Your counterclaim is for libel, slander. I see you have no witnesses. What proof do you have that she libeled, slandered you, and caused you to lose business?
Ma'am, we have several emails that she sent to customers, sales representatives, essentially people that were supporting.
No, just a second. Just a second. Well, I'd like to see copies of those emails. And then, of course, on the second part of your claim, that would be for libel or slander. The second part of your claim is that you lost business as a result of that.
Correct.
And then you would have to have a witness that says that they believed that, and therefore you lost business. So first, let's put down.
Sure.
First, let's put down on the screen the emails that she sent.
That's the first one.
That's not libelous.
Well,
next.
Judge Judy continues in a moment. And later today.
The contract that you had with the defendants is clear, and it's an enforceable contract.
But that wasn't the context.
Context. There is no context in a contract.
Janie Furling claims Russell and Juliet Slaybaugh owe for legal fees after the couple defaulted on the purchase of her business. The defendants are countersuing for loss of business due to slander and defamation.
Now, you did, in fact, default on your loan.
No, ma'am, we did not. There's a provision in the note that was properly offset on August 22nd because we followed the letter of the note, sent a certified letter to Ms. Furling. There was never a detailed response according to the letter of the note. And so on August 22nd, it was offset.
Do you still have your business?
Yes.
Are you still running your business?
Yes.
Goodbye. Judgment for the plaintiff in the amount of $48.75. Thanks very much.
Thank you, Your Honor.
This case is concluded. Be excused.
I respect Judge Judy. She heard the evidence and she ruled the way she did, and I'm actually relieved it's over.
I am pleased that I got reimbursed for my legal fees.
She called customers, all kinds of things like that.
I sold to the wrong people.
All parties in the matter of Isham versus Hughes, Dirksen Hughes. Step to the podium.
Jessica Isham is suing Dirksen Hughes for the cost of a cat and vet bills.
Ms. Isham, you purchased a kitten from the defendants. It was a Bengal kitten.
Correct, Your Honor.
They're very sweet animals. And you purchased the kitten from them on the 25th of March.
Correct.
Of this year. Is that correct?
Correct.
How much did you pay for the kitten?
$600.
And you found the ad where?
Online.
Do you have a written contract?
Yes, we have a contract.
The defendants gave you? I'd
Yes.
like to see it.
Sure. Try not to bend it. That's it.
Okay, this is the contract that you had.
Correct.
To the best of my knowledge, the above kitten is in good condition and health with no congenital defects. The purchaser, that would be you, must take the kitten to a professional veterinarian within 72 hours. If this veterinarian finds the above kitten to be in poor health or to have a congenital defect, the purchaser must bring a signed statement for the veterinarian as to the problem within 72 hours of the purchase for a full refund. Breeder will not be responsible for any veterinary bills. After 72 hours, all sales are final, except for congenital defects, which are guaranteed for 1 year with written confirmation from professional. Did not take the kitten to a veterinarian within 72 hours. That's clear.
Because of COVID.
From your statement. Whatever the reason, when you purchased the kitten, the country was already in the midst of the pandemic, which according to you was one of the reasons you wanted the kitten.
Correct.
So you could have modified that contract when you signed it and said, if I can't get to a vet within 72 hours, can I have a week? But you didn't. You signed this contract. Several weeks later, you took the kitten to the vet. And according to you, the vet found that the kitten had suffered some sort of an infection, which required surgery. It was expensive. They also took blood from the kitten and found that the kitten had some sort of a feline COVID. And you ultimately, after a lot of money in vet bills, decided that the kitten could not be saved and you had her euthanized.
Correct.
That's what happened.
Correct.
And you believe that the defendants should be responsible for your veterinary bills as well as a refund for the kitten.
Correct.
I don't see that, Ms. Isham. You had a contract.
Yes, but I think because of the
contract.
Because of the context, and also because she wasn't just having FIP, she had FIV, a CD chronic condition that she had when I got the cat.
Well, what you indicate in your complaint is that the defendants never had a blood test of the kitten.
Correct.
A blood test is not a usual test that breeders have of either kittens or puppies before they sell them. At whatever age they sell them, they very often have their vet checked and or have vaccinations. But breeders don't have a blood draw. I've certainly bought enough dogs and cats to know that.
Judge Judy continues in a moment.
They didn't breach your contract. They didn't breach the contract for the sale of
She had several
a kitten.
verbal contracts with me, aside from the written one.
You cannot have a verbal contract once you have a written one.
Real cases, real people. Judge Judy. Jessica Isham claims James Hughes and his wife, Penelope Dirksen Hughes, sold her a sick cat. Jessica says the cat had to be put down after only 2 months.
Now, what I found more interesting from the defendant's side is you called them several weeks later and told them about your first visit to the vet.
Right.
And at that time, despite the fact that they were under no contractual obligation, give you a new kitten if you want.
I didn't want a cat from them because they sold me a sick cat. Because their environment is what induced her health issues.
You're not entitled to your vet bills, and you're not entitled to a refund for the kitten because you had a contract, and the contract was clear. Your obligation was to have the kitten vet checked within 72 hours. If, and I don't mean to make you feel guilty, but if you had done that, it is possible that the kitten would not have had the kind of infection that it did if, in fact, it was in a cat fight, as you suggest that it was, and the fur was covering over this wound. But the vet, if it had been checked weeks earlier, might have found it before it infected it badly.
It wasn't.
So,
I wasn't able.
There's a. Go ahead. You weren't able to because
I was not able to make an appointment because most of the vets were closed. I got an appointment quickly after I realized that she was lethargic.
But Ms. Isham, that's not what your contract says. Your contract doesn't say that you have 72 hours after you notice some symptom of the kitten that you don't like. The contract that you had with the defendants is clear. It says your responsibility, if you want either a refund or a new kitten, your choice is to take the kitten to the vet within 72 hours of the product.
But that wasn't the context of
That
the
is what
environment.
you mean. I don't understand what you mean, context. There is no context in a contract.
Well, then why
It's a
did they
contract.
string me along? Like they were going to help me. Like they gave me information about FIP and where to get medicine, and they kept, we'll get back to you. Oh, we'll help you. Oh, this, oh, that. It really felt like
they were being nice people. They even offered you a new kitten. They're not
responsible. Why would I want another
for your
sick
vet bills.
cat? Like I don't.
I don't know why.
Judge Judy continues in a moment. Closed captioning sponsored by. Have you been cheated? Go to judgejudy.com, like us on Facebook, and follow us on Twitter.
They didn't breach your contract. They didn't breach the contract for the sale
she had several
of a kitten.
verbal contracts with me, aside from the written one.
You cannot have a verbal contract once you have a written one. That's the law. If you have a written contract, the only way you can modify that written contract is by another written contract. That's the only way you can do it. She did, in fact, say to you, in breach of that contract, but I feel sorry for you. I'll give you a new kitten if you like. She wasn't obligated to do that, which you could have had tested immediately, because what your complaint was initially was that the cat was lethargic because it had this infection. Came from. You brought the cat home on March 25th. What was the date of your first appointment with the vet?
4/16.
So that was 3 weeks later.
I got the appointment on April 4th for the 16th. That's when I could get in.
Whatever it was, you had the kitten at home in your house for 3 weeks.
Because based on the conversation...
Sorry, Ms. Isham, you don't have a case. Your case is dismissed. We're done. Thank you very much.
This case is concluded. You may step out.
Judge Judy continues in a moment. And on the next Judge Judy, a breakdown showdown.
As soon as we got on the freeway, the check engine light turned on.
You sold this car within a couple of months. Something doesn't smell right to me.
Judge Judy.
She was sick with more than 4 different illnesses.
I think she made the right decision. It was logical, reasoned, and informed.
That could not have occurred in that time frame that I had her.
It's very unfortunate, these things happen, but I don't think it's our fault.
You mistakenly parked in her parking space.
A neighbor's dirty deed.
There was laundry detergent all over the car, and there was a note.
Consider yourself lucky. Are you alleging that she keyed your car?
Scratched? Absolutely not.
Your problem is when you do something wrong, as you did, you lack the sympathy factor.
This is Judge Judy. Jessica Camacho says neighbor Jennifer Rumps Miller vandalized her car after she accidentally parked in her spot.
It's case number 32 on the calendar in the matter of Camacho versus Rump Miller. Both parties have been sworn in, Your Honor.
Thank you.
You're welcome, Judge.
Ms. Camacho, how long have you been living in your apartment?
A little over a year, Your Honor.
When did you move in? Give me the date.
July 2019.
And your apartment comes with an assigned parking space, is that correct?
Yes, it is.
And what number is your parking space?
60.
Now, Ms. Miller, how long have you been living in the complex? You both live in the same complex?
Yes, Your Honor, that's
How long
correct.
have you been living there?
Approximately 3 years.
And what number is your parking space?
64.
So, am I correct that they are 3 or 4 spots away from each other?
Yes.
Okay. This is what the case is about. Ms. Camacho, you claim that the defendant vandalized your car because you mistakenly parked in her parking space.
Yes.
You want to be compensated to the tune of over $4,000. While Ms. Miller acknowledges that she says she merely poured some mild detergent on your windshield to show her displeasure, causing nothing close to $4,000 worth of damage. So I have a couple of questions for you. Now, this incident happened in December of 2019.
Yes. Yeah, December 14.
And on December 14th, you'd been living in the building and parking in your parking space for approximately 6 months.
Yes.
So I'd like you to explain to me how, after 6 months, you, according to what you wrote, mistakenly parked in her spot in December.
Yeah, I came at night. We had Christmas dinner. I parked on her number.
I asked you why.
I wasn't paying attention.
Had you had too much to drink?
No, Your Honor.
I mean, had you parked in her spot before?
No, it was the first occurrence.
Was somebody else parked in your spot?
No.
No one?
No, no one. I just turned to park in earlier than, my spot.
And when you got out, and you've been making the same trip back and forth at least once a day from the garage to where you go into your house, right?
Right.
And so what you're telling me is you didn't realize that you were closer to your house
no,
than
Your
you
Honor.
were before.
I was with a family that came out of town, and we had gone to dinner, and I was distracted by them talking to me and spending time. So, no, I didn't notice that the walk was a little bit longer. It was 2 of us, my nephew that came from Utah.
Well, that's not a whole family. That's just one person.
Well, yeah.
So it was just you and one person?
Yes.
Okay. Now, when did you notice there was any damage to your car?
The next day, around noon.
Now, tell me what happened when you came down at noon. Who did you come down with?
Oh, I came down alone because I had to go have a haircut. So I came to look for my car, and it wasn't there. I thought, well, where's my car? And then I look over, and that's when I realized that I had parked on the wrong spot.
And you found your car in what condition?
Well, there was laundry detergent all over the car. The windshield wipers have been broken, and there was a note.
Do you have the note?
Yes.
I'd like to see it. And I assume, Miss Miller, that you wrote that note.
Yes, ma'am.
Consider yourself lucky you weren't towed. Do not park in anybody else's paid parking spot again.
Yes, Your Honor, that is correct.
And now I'd like to see photographs that you took of the car that day. That's the back windshield. Is that the one that was bent?
It was torn out, actually.
What about the front windshield wipers?
Right.
Were they torn out?
Yes. Can I change it?
May I see?
So that's the laundry detergent on the front, and here is the windshield front. So both of them on the front,
Got
too.
it. Okay. And the car itself, I see the laundry detergent on the windshield. Could you show me photographs of the laundry detergent on the car itself?
Yes, Your Honor.
Got it. Okay. Now, when you found the car in this condition, what did you do?
I called management, and I spoke to the manager. I told him what I found.
Don't tell me what they said. Did they have cameras?
No.
I assume you ascertained that the perpetrator of this vandalism was the defendant by the note that said you had parked in her space.
That's right.
When next did you meet Miss Miller?
December 14 was the incident. I called management because I wanted to settle this matter between us without involving the police. Management said they were going to contact the resident in question. I gave them 3 days before I filed a police report to hear from her and work things out between each other. I haven't heard from Ms. Rumps. On December 17, I filed a police report.
May I see that, please? Got it. So that was on the 17th. And when did you hear, again, from either management or from the defendant?
Management called, I would say, a week, telling me that she wanted it to meet an estimate of the damages.
Okay, don't tell me what else they said. Did you meet with her?
Yes, I did, in January.
You met with her in the office?
Yes, we did. The manager agreed to mediate.
Had you had the car fixed between December 15th and the January meeting?
I had it partially fixed, Your Honor. I fixed the windshield wipers and had it multiple times washed. I had an estimate by Toyota dealer. So, yeah, I had it partially fixed.
And how much did you spend to have it partially fixed that you have receipts for?
Well, roughly, I don't know, $250, $300.
This is a court. This is not a roughly. This is not a $250. You had 3 windshield wipers. I'd like to see what you spent to fix them.
Okay. So that's the wiper right there, one of them.
Oh, so you bought the wipers from Amazon?
Yes. My boyfriend offered to fix them.
Got it. Now, what is it that you say is wrong with the car physically that was a result of what Miss Miller poured on the car?
Yeah, so per Toyota diagnostic, they need to flush the AC. They need full engine flush.
What do they need to flush?
Because the detergent got on the vents, all the air vents.
You mean drip down from the windshield?
Yes, from the front windshield.
May I see the estimate, please? West Coast Toyota.
Yes, Your Honor.
Okay, guest request to have dents assessed. Did you allege in the police report that she caused dents in your car?
Yes, Your Honor.
Then show me where. Just point it out to me in the police report. Well, I see that. I just want to see where in the police report you attribute that to her.
Right here.
Okay. Could you point out where you allege in the police report any dents in the car that she caused? Just point it out to me. I may have missed it. Windshield keyed. You didn't tell me that anybody keyed your car. Are you alleging that she keyed your car?
No.
Where?
Well, there were some areas, though, but she said she didn't do it, so I didn't.
Absolutely not.
Okay, shh, don't. Miss Miller, your problem is when you do something wrong, as you did,
Yes.
you lack the sympathy factor if someone is exaggerating. Do you understand that?
Yes, ma'am, I do. I apologize.
Okay, can we get back to the bill, please?
This is just the total of the estimate of that day. I have 3 estimates of the work they recommended to be done on the car.
I only want to see estimates. Be very careful, Ms. Camacho, of the things that you are alleging that were caused by the defendant. Do you understand?
Yeah.
Good. Now, you took it to $20.
No. That was the initial evaluation of the car because I was scared, Your Honor. I didn't know what else was going on with the car. Maybe there was something that was not with the naked eye that I couldn't see.
Fine. So let me see what Toyota said. Is that from Toyota?
Yes, Your Honor. I went to 3 different places.
I'd like to see Toyota.
Okay, this is Toyota.
Now I'd like to go back to the photographs of what you are alleging, other than the windshield wipers, which I've allotted you $250 for the windshield wipers and $150 for the assessment. So far, we're up to $400.
Yes, Your Honor. The assessment includes that the Toyota dealer recommended the whole car needed to be painted.
I understand what... Okay, I got it. I want to see the picture of what you're alleging the damage was that she caused. You showed me one picture that looked like a little dent. I want to know if you have any others.
No, that's it, Your
You didn't
Honor.
show me a picture worth $4,000.
No, that was all for the dents, Your Honor.
Well, I would suggest that you get that dent pulled out. It's not a $4,000 dent. Okay.
No, but the paint job is.
Miss Miller, you want to tell me why, instead of just putting on a note on her car, if you do this again, it will be unpleasant. What you had to do was you had to see the urgent, come down, so it was a well-thought-out process. You want to tell me why an otherwise reasonable, intelligent person would do something like that?
First and foremost, I know what I did was wrong, and I feel great remorse for it, and I can assure you, the defendant, everyone, I would never do something like this ever again. There's no excuse for my behavior.
Great.
It was displaced frustration and anger, and it wasn't correct that I took it out on her. I did go through the correct channels. I contacted our security patrol that we have. I did not receive a response. I then contacted the phone number. There's a towing company placard. When I spoke to the gentleman via the tow truck company, he said, in order to have the vehicle towed, I would need to show a copy of my lease. It was 5 in the morning. I did not have that on me, nor did I know where it was at the moment. I was very upset and distraught.
What time did you come home?
5:15 in the morning.
Okay. So you tried to go through all the channels. You couldn't
Yes, Your
get
Honor.
any satisfaction from any. You didn't get satisfaction
Your
from
Honor.
anybody. I got it. Your initial statement to me really addressed the whole evening. You understand that it was the wrong thing to do.
Absolutely.
You apologized. You took out your frustration on Ms. Camacho's car.
Yeah.
She certainly had the car fixed. She's entitled to, but you caused $5,000 worth of damage to her car. Do you work, Ms. Camacho?
Yes, I do, Your Honor.
Since December of this year, have you been going to work?
Yes.
And you've been getting to work by your car?
Yes.
Unflushed, unsanitized. You haven't had it in repair for any engine problems since December?
No. However,
Okay.
Your Honor.
So, yes. Yeah.
You wanted to see more pictures. I have the after pictures of the decals that are permanently stained, as well as the paint. So the problem with the paint is that when you run your fingers through it, it's corroded because the laundry detergent chemicals in it corroded the paint. So now it's like a matte.
Well, that's a different picture. Just a
Yes.
second. That's a different picture from the picture that you showed me.
Yes, Your Honor.
Before with just one dent.
Judge Judy continues in a moment.
This is her rear spoiler. The paint is noticeably chipping and peeling. However, in my pictures that I took directly after the incident, it shows the same thing.
No. How did you get to court today?
In my car.
We're going to have somebody take pictures of your car all over, and we're going to come back.
Jessica Camacho has accused neighbor Jennifer Rumps Miller of destroying her wife after she accidentally parked in her spot.
When was that picture taken? After the car was washed or before?
Yes, after the car was washed.
Your Honor, I too have pictures.
I would like to see your pictures of the car.
I took pictures directly
is now.
after the incident because I knew in my gut what I did was very wrong, and I had a very strong gut feeling that somehow this would be turned against me and it would be claimed more than what had actually
turned
happened.
against you because you were wrong. Did you take current pictures of the car?
I took pictures right after the incident, and yes, I did take current pictures as well.
I'd like to see your current pictures of the car.
Your Honor, can
because
I say
if
one?
what she's showing me is the way the car looks now, and it's discolored because of the laundry detergent, then I agree with her.
This is the picture that I took directly after the incident.
Yes, that I got.
Okay.
I want to see pictures of her car now.
So this is the best
I mean,
picture.
I saw the pictures of it.
Yes, ma'am. This is the best picture that I have. This is her rear spoiler. The paint is noticeably chipping and peeling. However, in my pictures that I took directly after the incident, it shows the same thing.
No. I'm not interested in the pictures that you took directly afterwards. I'm
Well, the
interested
reason
in
being,
seeing
ma'am, it shows
what her
that
car looks now. Ms. Camacho, how did you get to court today?
In my car.
And is what you're telling me that the photo car looks now with what appears both on the door frame and on the bottom of the car, where the car appears to be stained
Yes, Your Honor.
and discolored?
Yes, it's
If
still
that's the way
discolored.
it looks today?
Yes, Your Honor.
Okay, very good. So we're going to have one of my clerks go out and take a photograph of your car, and we're going to recall this case. Do you understand?
Yes. Can I say one more
Because
thing?
I just have to set an amount of damages. If the damages are for the dents, which I assume some of them did, because when you had to get up to pour stuff on the windshield, you... Okay,
absolutely
well,
not.
whatever.
Well, honestly,
whatever.
I did break
I
the rear
wanna see
windshield
what the
wiper
car looks-
blade, and I did pour detergent, but that's
On-
all I did.
on the front?
On the front windshield and the driver's side window is where I poured the detergent. The very back of the car,
Yes.
I did break the windshield wiper arm completely, and that's all the damage I did.
Okay. If you say that it ate into the paint or whatever, is that what you're saying, that it ate into the paint?
Yes,
Ms.
Your
Camacho?
Honor, it's corroded.
Okay. If it did, don't speak. If it did, it will show up in the pictures that somebody is going to take, and then I will make an appropriate order. There's no question as to liability. The defendant is liable. The only question is how much. Now, we're going to have somebody take pictures of your car all over, and we're going to come back. Thank you very much.
Continues in a moment.
I'd like to see the damage.
My car is white, Your Honor, and now it's matte, so it doesn't have a shine anymore because of the corrosion from the laundry detergent.
I did call Arm & Hammer, and I did ask them if they have any testing.
You can't tell me what Arm & Hammer told you.
Real cases, real people. Judge Judy. In a case recalled from earlier today, Jessica Camacho is suing her apartment complex neighbor, Jennifer Rumps Miller, for vandalizing her car after she accidentally parked in her spot.
Judge, this is a recall of case number 32 in the matter of Camacho versus Rump Miller. Parties are reminded you're still under oath.
Thank you, Bird. Ms. Camacho, did you take photographs or did someone take photographs of your car that you wanted to show me?
Yes, Your Honor, we did. So
I'd like to see the damage. Okay, so around the door frame,
yeah, those are the decals.
I see that there is a discoloration. Anything else?
Yeah.
I'd like to see it.
We also made a video of my car is white, Your Honor, and now it's matte. So it doesn't have a shine anymore because of the corrosion from the laundry detergent. So laundry detergent is not for cars, it's for clothes.
No, just a second. I just want to see the pictures. Okay. So that came from the laundry detergent. Okay,
yes.
What's
yes,
next? And the door frame.
Yes, the front where the mirror is at, it's gray. It's not black anymore because of the corrosion.
I don't know if that's from that.
Well, the three estimates that I got, they all agreed.
Just a second. Well, I do see that there is some evidence of still splatter on that. I see it. Okay, very good. Now, you have an 11-year-old car. You're entitled to have the car repainted.
Thank you,
Because
Your Honor.
what you did was you put stuff on there that was clearly corrosive on
Your
parts
Honor?
of the car, and you don't have to live with that.
Your Honor, may I interject?
Yes.
I did call Arm & Hammer, and I did ask them if they have any testing.
You can't tell me what Arm & Hammer told you.
Okay.
That's hearsay.
Okay.
If you have an expert here, I'm prepared to hear them.
I understand that.
But
I do have pictures.
Without an expert, I just saw the pictures that were taken today. And so I have to make a judgment as a lay person as to whether or not the discoloration that I just saw plausibly was a result of you pouring detergent on the car.
Judge Judy continues in a moment. Closed captioning sponsored by... Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
Okay. Now, there are certain things that if you use them in the regular course of your business, in a laundry, they're not going to do, which is to clean clothes and take out stains. Just as a soft drink, if you drink it, it may not be good for you, but if you put it on a car, it corrodes the paint of the car. So if you use something that is not designed for, especially under these circumstances, and Ms. Miller, I have to tell you that I commend you for saying I acted out of frustration, and I don't think that you actually intended to cause permanent damage to the paint on her car. You did, in fact, intend to cause damage to the windshields of her car, which you
not
acknowledged.
The windshield, the arm. But
in
yes,
frustration,
ma'am.
frustration, you broke. Judgment for the plaintiff in the amount of $3,500. You can get your car painted for that. We're done. Thank you.
Case is concluded. Parties are excused.
And on the next Judge Judy, his cheating was exposed.
He was still involved with Claudia.
He was lying to the both of us.
Couldn't you tell who he was?
Yeah, I fell for the sweet nothings.
Next Judge Judy.
I had already had my car broken into twice, my carport once, and I just had had enough.
I made a mistake. It was an honest mistake. I didn't mean anything by it.
It was misplaced anger nonetheless.
I was distracted. I admit to that, yes.
I understand what I did was wrong.
Judgment was fair.
But I do feel that the paint job is extortion. I feel that it is an astronomical request.
And I hold nothing against Miss Jennifer.
Definitely have it towed. I will not be behaving in such a manner ever again.
Park on the right spot, yes.
Lord knows I have a change heart.
You thought it would be fun to start a YouTube channel.
A quest for fame becomes a fight.
It was his idea to start the channel.
This channel was never my channel. It's always been her channel.
Now who's the one?
Wow.
Putting on a show.
He wasn't paying me half for all of the things that I put into the channel to start off.
Well, what she doesn't understand is this was her first priority. This YouTube channel was her first priority. It's not my first priority.
This is Judge Judy. Keshwan Clark is suing her former friend, Corey Ingram, for the cost of props to start their YouTube channel.
Yeah, it's case number 48 on the calendar in the matter of Clark versus Ingram. Both parties have been sworn in.
Thank you, Bird. Miss Clark, you and the defendant were friends, according to you, for a very long time. And according to you, you thought it would be fun to start a YouTube channel. I don't know what that is or what it's...
Videos on there for... It was content for fans to see. The videos could be comedic skits, vlogs, anything like that.
And how do you make money doing that?
We haven't made money from it yet, so for you to make money from it, you have to have a lot of people watch your videos. So you have to have a lot of subscribers, and your views have to be extremely high. You get like, after 1 million views, I think you get like 5 cents per view.
When did you start this YouTube channel?
It was March 4th, 2018.
2018?
Yes, 2018 is when we started our YouTube channel, yes.
Great. And in order to start the YouTube channel, you had to buy certain equipment. Is that right?
Yes.
In order to start it, tell me what equipment you had to buy.
So for our YouTube channel, I purchased the camera, the massage wand, the camera bag, the reflector, the mic, the photo stand, the electric muscle stimulator. Those are all the things that I purchased for the channel.
Okay. And that was 2.5 years ago.
All of these weren't purchased 2 years ago. Some of them were purchased 2 years ago. And yes.
Then you didn't answer my question. I said, what items did you purchase in order to start your YouTube channel?
Yes, to start the channel. Yes, to start the channel.
You needed, don't look down. What did you need to start the YouTube channel in March of 2018? Did you need a camera?
Yes.
Did you?
To start the channel, yes.
And all of those things you needed in order to start it, correct?
Mm-hmm. Yes.
So those things were bought 2.5 years ago, if they were bought to start it.
Yes.
Now, according to what I read in your complaint and in his answer, you stopped making these videos in June of 2020.
Yes, that's true.
Why?
We stopped making the videos because he wasn't putting in his part. He wasn't paying me half for all of the things that I put into the channel to start off. And as our YouTube channel went on, I felt myself having to force him to film videos. He didn't come up with much of any ideas. This YouTube channel was his to start. It was his idea to start the channel. I just helped out by purchasing a majority of the things that I knew we needed to start the channel.
Yeah, that's what you memorized that's in your complaint. So for 2.5 years, you worked together to make videos, and when COVID became a problem, it wasn't so easy making videos outside. Be a fair statement?
Yes, yes.
Is that your problem?
Well, we were making videos inside.
Oh, you were?
Yeah, during COVID,
Did you continue to make videos? Did you continue to make videos inside?
Yes.
In March, April, May, did you continue to make videos inside?
Yes, in my home.
I assume people watching you.
Yes. We still do.
The two of you did it together in your home?
Yes, in my home, yes.
So did the defendant come to your home to make the videos?
Yes, we were never at his house to make any content. It was always at my house.
All I asked you was, did the defendant come to your house to make the videos?
Yes, ma'am.
And who do you live with?
I live with my parents.
Okay. So it was just you, your parents, and the defendant.
And the house is also my 2 sisters.
Now, where did Corey live?
Corey lives in Vista, so he's 7 minutes from my house. I live in Oceanside.
And he came to your house, according to what I'm putting together, at least through June.
Yes.
How did he get to your house?
He drove his own car to get to my house.
What kind of a car does he have?
I'm not sure the brand of car.
What kind of a car do you have?
I have a Chevy Malibu 2015.
What kind of a car did you drive to the studio today?
The Chevy Malibu 2015.
And what kind of a car did Mr. Ingram drive?
His car? His gray car?
I don't know. I'm asking you.
Yes, his car.
And when was the last time prior to today that you saw Mr. Ingram?
Ooh, it's been a couple months. I haven't seen him in a couple months since our
last video.
Is June 12th, I think. I'm not sure of the exact day, but I know it's June.
And what happened, Mr. Ingram, at that last video? You want to tell me?
Yeah, it was a reaction video to a music video that she wanted to do. This channel was never my channel. It's always been her channel. I don't know why she tries to say it's mine.
Don't go off on a tangent with me, please.
Got it.
I asked you what it was about.
A reaction video.
And can you tell me why it is that, having been working closely together in what you referred to as a we project, the last video we made, which is what you say in your answer, tell me what happened on June 12th that caused you and the plaintiff not to see each other again?
Well, what she doesn't understand is this was her first priority. This YouTube channel was her first priority. It's not my first priority.
Just a second. That's not what I asked you. Don't tell me what she has to understand.
Okay.
Don't tell me what she knows. Don't tell me what she thinks. Just tell me what happened on June 12th that caused two people who had been working together for 2.5 years to stop speaking. We're now in October.
Got it.
What caused you to stop speaking?
Life got in the way. So I was going to school at the time. I was going to work. I was also going to the gym. Before this, to better my life, before this, I was super skinny. I was unhappy. Every time we'd film a video, I saw myself on camera and I was like, wow. So I was my own bully in my head.
So you were the subject of some of the videos?
Correct.
Was the plaintiff also subject of the videos?
Yes.
What about her siblings? Were they the subjects of the videos?
No, not at all.
What about her parents? Were they ever the subjects or in the videos?
Her parents were in one video, and it was like a who knows me better type video, mom or best friend.
It was never posted. And yes, I've had my older sister was in one of our videos. Sorry.
You're interrupting.
Sorry.
Now, from March of 2018 until June 12th of 2020, when did the plaintiff ask you for any money towards the video equipment
She's never asked me for any
that
money.
she had purchased?
She's never asked me for any money.
Okay.
Wow.
So, Miss Clark, between March of 2018 and June of 2012, what proof do you have that you asked him to pay any part of this video equipment?
I don't have any proof.
What proof?
Yes. He promised that he would go half and half with me on this channel. That's why I bought all the things I bought. And this channel was his idea.
I think you should sell the equipment. Sell it.
I can't sell it.
You have the most ridiculous says you want some of your props back. Your life is too busy for props for a video.
Right.
You go to school. Don't speak. You go to school, you work out, you have a job, you have things. You don't have any use
Of these
for
props. Correct.
Do you understand?
Right.
Good. We're done. Case dismissed. We're finished. Goodbye. Arrivederci. Sayonara. Goodbye.
This case is concluded. Parties are excused.
This was his channel. It was his idea. That's why it's called Corey and Casey. It's not called Casey and Corey. It was his idea.
Our very first YouTube video we ever made, the question was, why did you guys want to start this channel? And I said, well, I wanted to start because you wanted to start. Why did you want to start?
We're doing a lot of pranks, a lot of reaction videos, a lot of ratchet videos. Whatever they asked for, the audience asked for, we made.
Well, we were been told that we have a really good personality together. People like us together. And so she's more rambunctious and she's more out there. She loves the social media atmosphere.
Nothing. I had to basically beg him to come to my house to film content for his channel that he wanted us to do.
I had other priorities that hit way above this YouTube channel.
Nothing. No, I'm not even kidding you.
So I was, like I say, going to school, I was going to work, I was going to the gym, to better myself, to make my life better. And I can't just help her without helping myself first.
I mean, I don't want to throw our friendship away over some videos, but I still want to keep the channel something.
I mean, the friendship should continue. She's just not allowed to go anywhere near my wallet.
All parties in the matter of Shoemaker versus Aragon. Step to the podium, please.
23-year-old Karina Schumacher is suing her former roommate, 23-year-old Christine Aragon, for the return of her security deposit, damaged property, and stolen eyelashes.
Ms. Schumacher, do you go to school? Is that what you do?
Yes, I go to UCSD.
You go to school?
I go to UCSD.
And Miss Aragon, you're a student as well?
Yes, Your Honor.
And you were living in an apartment with other students?
Yes. Yes.
How many other students, Miss Schumacher?
4.
And did you sign a lease?
Yes, we did.
On what date did you sign the lease?
October 29, 2019.
And when did the lease expire?
At the end of June in 2020.
The defendant was your roommate. You're alleging 3 things. I'm going to get to them in relatively short order. It is your claim that in November of last year, almost a year ago, the defendant took a package that belonged to you inadvertently. You're not claiming that she stole it, but inadvertently took this package that contained eyelashes that you had ordered.
Yes, Your Honor. I ordered eyelashes in November.
I don't care. Just look at me. Where? About your eyelashes. Do you have her eyelashes?
Yes, Your Honor. I have her eyelashes. I have them with me.
Give them to her.
Okay.
Give them to her.
Okay.
Give them to her.
Okay.
That would be a now.
Okay. I did bring them, Your Honor.
No, but they're outside.
Is somebody going to bring the eyelashes?
We'll wait. Go get the eyelashes. We'll wait.
Judge Judy continues in a moment.
In September, when this happened, you said you charged her. What did you charge her?
I charged her $60, so it originally cost me $80.
Stop. Who cares? What is wrong with you?
Karina Schumacher says former roommate Christine Aragon owes for a security deposit and property damage caused by her dog.
Now, do you have her eyelashes?
Yes, Your Honor. I have the eyelashes with me now.
Could you give them to the plaintiff, please? Now you have your eyelashes back. Cause of action number 1, resolved. Cause of action number 2. Did you damage her vacuum cleaner?
No, Your Honor, I did not. Damaging things, but I'm a student too. I was studying finals.
Just a second.
Oh, sorry.
All I'm asking you is, did you knowingly damage her vacuum cleaner?
No, Your Honor. Objection, Your Honor. I have evidence right here.
Just don't speak to me unless I'm asking you a question. How was your vacuum cleaner broken?
The cord of the vacuum was chewed up by her dog.
Did you see that?
No, but I do have a picture
of the chewed up cord
in her room.
I'd like to see that.
Yes.
Okay. And on what date was the cord chewed through?
September 26, 2019. I also have a second vacuum.
And what did you just a second. Did you get it fixed?
No, it was completely ruined, so I just charged her for part of the full amount, the amount that it cost me.
Hey. In September, when this happened, you said you charged her. What did you charge her?
The amount that I paid.
How much
for the
money?
Vacuum. I charged her $60, so it originally cost me $80.
Stop. Who cares? What is wrong with you? You took the $60 from
No,
her.
she never paid me.
Just from her?
No.
You didn't?
I asked her.
Did she ask you for the money for the vacuum cleaner?
Your Honor, yes, she accused my dog of breaking it, but there are other animals on the lease too. My roommate has a big dog, and Karina even brought in 2 rats into the apartment, and one of the rats crawled from her apartment to my room that I share with my roommate, and it died on the pillow.
Just stop.
Yeah, sorry.
I know you have a story that you want to tell me. I have to tell you, ladies, I am so disinterested in this case, but I'm going to get through it for the sake of getting it resolved.
Judge Judy continues in a moment.
Where did you get them from?
My ex-boyfriend, he had a snake and he was going to feed them to it, and I decided to take care of them, but they ended up dying because they're just feeder mice. Your Honor, my roommate slept on those rats.
Real cases, real people. Judge Judy. Karina Schumacher says former roommate Christine Aragon owes for a security deposit and property damage caused by her dog.
Now, forget the vacuum cleaner. The next cause of action is money owed for the return of security deposit because you say that her dog caused damage.
Yes.
How much was your security deposit?
It was originally $200, but I'm only charging her $129 because I am paying for part of the cleaning fee of the apartment.
Did they keep your security deposit?
Yes, Your Honor. Nobody got their security deposit back.
Just answer my questions. I'm not really interested in all your nonsense. You moved out in March, is that correct? Because of COVID, Miss Aragon. School closed down in March?
We moved out June 2020, Your Honor.
I thought you said in your complaint that she moved out in March.
Yes, she moved out earlier. She went back home because of COVID. She came back occasionally to the apartment, but she moved out.
Did she pay rent?
Yes.
Did you pay rent?
Yes, I did. I have my rent receipt.
Okay, just a second. I didn't ask you for the rent receipts. I just asked you if you paid your rent through June. Now, everybody lost their security deposit?
Yes, Your Honor.
Is that correct, Ms. Schumacher?
We lost the security deposit because of carpet damages that her dog caused. And I have a video.
Okay, Just a second.
Okay.
There were 4 girls in the apartment?
Yes.
How many dogs were in the apartment?
There were 2. One of them was under the leash.
How many, just a second, were in the apartment?
There were none. There were 2 rats, Your Honor.
Just a second. Did you have, at any time during the course of these, very easy, all I have to do is call up one of these other girls. Did you have any pet rodents in the house? That's either a yes or a no.
Judge Judy continues in a moment. Closed captioning sponsored by... Want justice? Go to judgejudy.com. Like us on Facebook and follow us on Twitter.
How many rats were in the apartment?
There were none. There were 2 rats, Your Honor.
Just a second. Did you have, at any time during the course of these, very easy, all I have to do is call up one of these other girls. Did you have any pet rodents in the house? That's either a yes
2 mice
or a no.
For a month in a cage.
So the answer is yes. What did they look like?
They were white, and they had red eyes.
Where did you get them from?
My ex-boyfriend, he had a snake, and he was going to feed them to it, and I decided to take care of them because the snake didn't end up eating them, but they ended up dying because they're just feeder mice. Your Honor, my roommate slept on those rats. They were kept in a cage.
What about you, Miss Aragon?
Yes, Your Honor.
Are you living at home?
Currently, yes, I'm at home. I'm in a house now with my roommates that she lived with before, and we're all friends and we're on good terms. Objection.
So you are not at home with family, you're with 2 other roommates.
I'm at home with family as of right now, but my house is with those 2 roommates from before. We're renting it together.
You have a lease with them?
Yes, that's correct.
I don't understand. Are you living with your parents, or do you have this house?
This is a house that we're renting. We have a lease with my roommates.
Who's we?
Me and our previous roommates from before.
And where are you living?
I am living in a new apartment near campus.
With whom?
2 of my friends.
Good, very good. Okay, I assume that you have an awful lot of time because going to school virtually gives you probably a lot of extra time, which is why I have to see you today. Your case is dismissed. We're finished. Goodbye. Goodbye. Adios. Farewell.
This case is concluded. Parties are excused.
And on the next Judge Judy.
I have a police report. Your Honor, you're an exceptionally bright woman.
All I want to do is see the evidence. I don't want you to tell me how bright I am. Actually, I already know that.
Judge Judy.
It's about my dog, but the fact is there were other animals on the leash. She completely ignored her rats that were on there too. Her dog was not on the leash. On the leash it says that any dogs that are not emotional support animals or service animals cannot be in the apartment. And her dog was not. And none of these eyelashes or lost vacuum was an issue until the move-out statement, as well as all the damages to the vacuums and the eyelashes that she stole from me that she never paid me back for. It's just crazy to me. Everybody split the bill. We're all in the lease. We're all responsible, as it says in the contract, and she just does not agree and does not want to pay. For asking her to potty train her dog. No, they did not. She's just accusing my dog of everything, and it's just like, I honestly thought like it was just to the extreme. Pick your roommates better. It's just crazy to me. I still can't believe that I'm here right now and that she actually did take me to court over some eyelashes and a vacuum.